Now, I should have called for an adjournment. I didn't. I'll call for an adjournment and now we'll reconvene. Thank you for your indulgence. We're now going to move on to earthworks, and we're going to hear from Mark Adam, who I believe is a geotech expert. Are you hearing us, Mark? That's great. We're in your hands to run us through your evidence, please.
Would it be helpful if I just very quickly go through? Mark has been assisting me in responding to submissions and also the supplementary evidence. The main ones that I'm addressing in my supplementary evidence is in relation to Stony Creek, who have sought, if we put the planning matters to side and look at the kind of more technical aspects, they are seeking allowances for fences and changes to the standards.
Excuse me, have you got a page there?
Yeah, sure. So it's I'm looking at paragraph 10 of the supplementary, or my statement of evidence. Supplementary, yeah.
There is a procedural issue with fences that I think I need to raise first up, and that is that the council withdrew some provisions in the plan. And how does that impact on what is in your report, and what is the standing of the submissions then that were to that rule that was withdrawn?
So the rule is the fencing rule, as notified, had a width and depth limitation and a linear limitation. The rule through the 42 report was changed to not have those restrictions and instead rely on the cut depth standards and the batter slope standards, which would then allow for a greater area of earthworks. So they're more permissive through the 42. Is that, have I misunderstood your question?
Sorry, Keith, are you referring to the eco provisions of removing vegetation connected to fencing? Is that what you mean by council removing that from the immediately legal effect rules?
I understand that it withdrew the distance that cuts could be made. My speaker wasn't on, apologies. The rule that was withdrawn related to the width of earthworks that could be undertaken as part of the construction.
Yes, I think that's the eco rule, not the earthworks rule.
Yeah, that was just in relation to the removal of indigenous vegetation. It didn't impact the actual earthworks standards, just because it had immediate legal effect, which is why council wanted to remove it, so it didn't have legal,
Right, yeah, so we've got that recorded because, it may come up with people speaking later today. Now, just from admin point of view, I see we've got some submitters in the room. So we might deal with questions that need to go to Mark, and then we'll hear from the submitters that we've got.
So yes, I've made some further changes to some of the earthwork standards as a response to supplementary evidence. These are set out on, if you look in paragraph 24, talks about cut depth and fill height, where we're maintaining the cut depth fill height, but in relation to boundary making an allowance for post and wire fences in the general rural zone, and in relation to EWS2 unretained batters, we have made an allowance to have a 1-in-1 batter slope if constructed in rock. So those are the changes I've made in relation to the Stony Creek submissions. And I think that's the main ones I would relate to anything geotechnical. The others are more about planning.
Look, I think I read, in fact, I'm sure I read in the 42A report, there was some comment by Stony Creek, and it applies to other rural people, about provision and width and disturbance for farm tracks and fencing, which are, you know, generally normal part of agriculture and permitted. I'm wanting to know how you've addressed that.
Yes, sure. So fencing, so land disturbance and earthworks for fences are subject to it doesn't have an area restriction any longer, because that was the submission in part from Stony Creek, but others as well, that was too limiting. So instead we're relying on the earthwork standards. And so the building of farm tracks and farm infrastructure does have an area limitation, but it's the same as for roads and network utilities.
Am I correct? Is my recollection correct in that that's now become a permitted activity, farm tracks, farm fencing?
Yeah, it's always been permitted. It's just that in the notified plan there was a width limitation on fencing, which then was removed, and instead we're using the standards to allow for more flexibility. But in the farm tracks was always permitted, subject to conditions.
Right. So we're back on permitted activity with no restriction, and I think the concern was machinery that might undertake that work under the normal process of farming. Thank you for your answer. Carry on, please.
And that's all right. Yeah. So if you had any questions about geotechnical recommendations or any of the standards, happy to direct those.
So if we work off your supplementary and where things have got to, it might be helpful to understand why you got there based on technical advice. So you've pointed us to the change to Earthwork Standard 1, cut depth and fill height. Mr. Allen, are you looking at these standards as we're talking to you?
Yep.
Maybe if you could, when you're looking at that Earthworks Standard 1, from a technical perspective, why are those parameters important to us?
So this EWR1?
S1. So it's paragraph 24 of the supplementary evidence, which is page 6. EWS1. So we've just had it explained that works will be managed by the standards, and that there've been some changes to those standards, and those changes have been done in consultation with you. So when we're looking at EWS1, can you help us understand the significance of those parameters and the relationship? Yeah.
So typically they're generally geotechnical rule of thumbs, but most of them are taken from previous, so there's other councils that have similar standards. So we just sort of use those ones, but they're basically based on batter, a 2-to-1 batter or a cut height. We've sort of deemed it as geotechnically, that's a reasonably safe margin. is similar. So if you start, technically, if you start going quite high with your cuts, you have more chance of having instability. So that's sort of just the limits that have been set. Does that answer your question?
So there's no concern with erosion from those cuts?
So the 2 to 1, generally why we do a 2 to 1 is that limits erosion, but we always usually say that if you are doing cuts in any material that you should revegetate. A 2 to 1 cut gives you a good chance of revegetation. After that, it starts to become quite tricky. You can't get the soil to hold on the slope. It's generally referring to topsoil.
I'm just wondering, and it may apply to the planner, when we had the hearing for development areas, it was indicated, particularly in the one relating to Reby Road area, that that land will be used for agricultural purposes in the interim. So it's not in the rural zone. Should, where it says, except for construction of post and wire fences, general rural zone, should that exception also apply to development areas and even the rural lifestyle zone?
Sorry, you sort of break up a little bit there. Can you repeat the question?
The planner's going to answer it for you, I think.
Yes, so the reason for saying it's in the general rural zone is that those are typical farm fences. And because the land areas it gives a natural separation between activities, so that on those bigger blocks you're probably not going to need to do earthworks that close to boundary generally, unless it is for a boundary fence, whereas on other properties, including lifestyle zones, the density, I suppose, is higher, or potential density is higher.
Honestly, in practical terms, you'd expect that those boundary fences have been there for
Yes.
a very long time already.
Is it a matter of the zone, or is it a matter of the nature of a post and wire fence in terms of its earthworks requirements? So that's half a technical question and half a planning question. But, you know, a post and wire fence, the earthworks component, I think the evidence in front of us increases if you have slope matters coming into play. Is that the right way to think about it?
Yes, so basically if you sort of think about it maybe in the past they've used, to construct fences, they've just done it by hand and used small machinery. And now to save time and effort, I guess they use excavators or bulldozers and use larger machinery, and in the process of that it creates bigger cuts. Generally when it's going across the slope, it's not really a concern when it's up and down the slope. And so those earthworks that have been undertaken are generally very close to being the same as a track. And so you've got to be a little bit careful of taking extensive earthworks and giving fences an exemption, when in other areas you're doing the same thing for a track.
So is that part of what's happening here? Because I'm trying to work out what is the fence and what is the track and what are we managing? Because I'm thinking like the works associated with the post and wire fence itself, you know, it's your post holes, but actually what we're talking about is the track for the vehicles to get to the place where you can do that work.
Yes, exactly. So you can't drive a tractor along a slope that's on a too steep slope. It won't be able to put the post in the hole. So that eventually they create a track
Just to interject there, some of the images that Stony Creek have provided through their evidence kind of show that. It's not the actual post holes for the fence, it's the earthworks to put the fence in that then create essentially a big track, I believe.
But then should we just call it what it is, the creation of a track, and be managing that, whether it's used for building a fence or whatever it's used for?
There is a specific rule about farm tracks in my evidence. I am talking a little bit about that crossover because, yeah, there is, especially on a steep property like this, there seems to be quite significant crossover between the two.
May I suggest that a track to take farm vehicles on a regular basis is different than a cut to provide the erection of a fence at one time. It is different.
It is a defined term, a farm track. There's a definition that goes with it, which does set out some parameters of the use of it and the function of it. I would have to find a definition.
In other words, based on that, there is a deliberate distinction being made between the regular farm track and a cut or a track used only for the access to install and maintain the fence.
Yes, so if there is a cut, so the Stony Creek property is perhaps not a typical property, given it has some challenges with slope. On many farm properties, I would expect that you would be able to drive a vehicle without cutting a proper track for it. Yes, if it is just preparing for a fence as opposed to building a track in a fence, they are two different earthworks activities, in my opinion.
May I make a suggestion that some of the submitters in future may want to respond to that question and add some clarity. Mark, do you have any more information for us, or does anybody have any questions of Mark? Yeah?
I have one, and that's because you were talking about the 2-to-1 ratio and the safety of that, and I understood when you were saying that, although you didn't say it, that was around earth, but of course one of the changes to EWS2 that I presume has come out of dialogue with you is the 1-to-1 where we're talking about construction with rock. Could you explain the difference between the earth 2-to-1 and the rock 1-to-1?
Yes, typically that's actually from the building code standard. So the rock is generally obviously a lot more stable than soil, and you can actually increase rock, and if you've got driven on a road, it can almost be vertical. But without going past 1-to-1, you'd probably be risking it. You'd probably want a geotechnical assessment, but standards would say that, and using the building code standard as an example, the 1-to-1 cut in the rock is perfectly stable.
That's all from me, thank you.
I've got no more questions of Mark.
So we'll let Mark go and move on to jet boating.
Yes. Thank you very much for your input, Mark.
Thank you.
Okay. We'll now hear from, go back and hear from the jet boating people. We were dealing, before you came, with activities on surface water, and I know you've made submissions in the past. If you, we've obviously read your submissions and listened to your submissions. If you have any additional information, we'd like to hear it. Failing that, there may be questions from, yep.
There we go. Oh, thank you for having us. My name is Kyle Simonson for Jet Boating New Zealanders Council. This is Nathan Barker, whose evidence you've read. I just want to touch on a couple of things, and then I suppose we can hear from Mr. Barker as well and jump into questions, because I would like to keep it short. I know you've got a long day of technical evidence. We just did a nice drive up and down the boatable section of the Matoda this morning with Eddie McKenzie, who's in the back, because I'm not from here. And I think it really brought home for me the key value of the Matoda for jet boating in a general sense, which is that yes, it allows people to access the water, which is a unique activity itself, but it's the feature of the Matoda that I want to highlight is that it's a really accessible river, so it promotes jet boating for families and larger groups of people who haven't done it before, people who want to get into it, people who want to enjoy the same things and values that other rivers enjoy, just in a different way. And that's probably something I wanted to highlight to go into the melting pot when we come to Rule 7 and how that's formulated and how we weigh up the values. But I think it's easy to forget that jet boating is a really inclusive and can be family-friendly activity. Certainly that's what JBNZ's interest is in recreational jet boating and events that are focused on having families participate. And it is an activity that's coexisted with other users and Indigenous biodiversity for 60 odd years. So with that in mind, jet boating New Zealand obviously supports having a clarity in the ASW chapter, because there's no rules currently, and it supports the objectives of having sustainable recreational opportunities, and it also supports that policy framework I talked about in the submissions, where you've got the difference between how we approach recreational as opposed to commercial activities. And I think there's more permissive wording in Policy 4 about allowing some contest between environmental values in the interests of allowing for recreation. Not so much for commercial, that needs to be consistent with the values that are already there. Those need to be coexisting without interference. But I think there's a level of tolerance that's built into Policy 4 for something as important as jet boating and other river recreational activities. So really, Jet Boating New Zealand's concern is that from that melting pot in Policy 4, which we say is fair and appropriate, we've then got the proposed Rule 7, which restricts, in my submission, casual and recreational jet boating by requiring a resource consent for 10 months of the year. In circumstances where, respectfully, the cost of that for users who are doing one-day trips with their family, or JBNZ who are hosting events for families to get involved in jet boating, the cost and uncertainty of that is significant, and we encourage the panel to be careful before that level of restriction is imposed. And I should just note there's obviously the other external constraints on the frequency with which jet boating can and does happen as well. So the time and availability, you need the weather conditions to be right, you need sufficient flow in the river, and then there's the ES bylaw as well, which is already regulated. So it's not a floodgate situation where we're going to have a complete increase in usage. And just on the rule that we'd put forward, I have actually brought some new copies of it because I realised there was a typo in the submissions last night, sorry. At point 4, I just added a couple of words that didn't make sense. I think I forgot to delete them off track changes, sorry. So I've used my auntie's printer and I've got 4 copies. One is the clean copy, and then one has the changes tracked as it should be. As I say, they're just small typos. They don't change the meaning of anything, but I thought if it assists. She didn't have a stapler, sorry. Apologies.
I guess from a legal perspective, and Keith Ovell, I'm not actually partaking in any of the decision making on this chapter, but there's issues that come up elsewhere, and I guess we may need some guidance from legal advisor that we've got present. So the effective 4B that you've written there is that it's permitted if temporary uplift to speed has been granted. Now, if it hasn't been granted, the way that rule is written, it needs a consent from the Gore District Council. Is B needed
Well,
at all?
I suppose it technically could mean that, but the practical effect would be that if there's no consent from, or no uplift granted by Environment Southland, then you're not going to be able to meet the threshold to get the discretionary activity. So
Yeah, so in a couple of places in the plan, we've got this may require a building consent, I guess for the panel to decide, do we actually need something there saying you also need a consent from Environment Southland to undertake this activity?
that might be a more effective way of doing it. I think in the
And
proposed...
in the notes, yeah.
Yeah, and the proposed version had a note. That might be a better way of doing it without repeating a regulation. Yeah.
So lots of my questions this morning were around this idea of jurisdiction. What's the district plan trying to manage versus what's the bylaw doing? Because I think your answer just then wasn't quite correct. I think if we read the permitted rule the way you've drafted it, 4B, and that speed uplift hasn't come through from ES, it would trigger a discretionary process, right? And then the district council can issue a resource consent on a basis following the policies and thinking about the matters. It's just that you wouldn't be able to utilise it without the authorisation from the bylaw. So I've spent most of my time thinking about this issue around this idea of jurisdiction, what's the value of the what the district plan is doing compared to what is required under the bylaw, which is another authorisation that won't enable you to proceed unless you've got it. I would read that it wouldn't prevent the district council from granting a consent. It would just be unable to be exercised until you had the authorisation from ES.
Yeah, I think that's actually correct. I suppose I'm just thinking through. There's still going to be a barrier to people, you're right, exercising it. So I suppose is there a better way to word it? I think the note might be the most effective way rather than repeating a regulation, because there is that cross-jurisdiction issue.
Because the other thing that I'm really grappling with here is that the bylaw is managing not just speed, it's managing timing and location as well. Those three things, timing, location and speed, all managed by the bylaw. And we also are, through the district plan, talking about managing those three things as well. So then the question comes, if we implement something in the district plan that is out of alignment with the bylaw around location, timing and speed, why are we doing that? Being very clear about why we're doing that, what is the effect of doing that? Because one way to think about this, I think, is that the bylaw, it's a known quantity, like some of the evidence coming through from Jet Boating New Zealand is based on that known quantity, i.e. the frequency and timing of events that have been taking place, and they've been taking place under the bylaw. So what I see is DOC coming forward and saying we're actually really comfortable with this status quo and all this stuff about timing, speed and location that is a known quantity under the bylaw. So if we deviate from timing, speed and location in the district plan, I think the problem we've got is we don't have, that's an unknown quantity for us at this point, in terms of the consequences of that. And so we've got evidence from Jet Boating New Zealand coming in to contribute to that. But I think right at the core of it, that's one way or another you'd need two authorisations, either a permitted authorisation under the district plan and an authorisation under the bylaw. Yeah, and if those two things are out of alignment, the activity really can't proceed unless both things are in alignment.
Yeah.
That was one of the concerns, I think, right at the start with that, the way that was written, is that we could end up with two governing documents that actually contradict each other. Just making sure there is alignment between the two. But,
Yeah, but I think it's important just to focus on the different roles that those two sets of rules play. So the bylaw is very much health and safety focused. And there's obviously, on top of that, you've got the maritime rules, which apply everywhere about how you can drive a boat, just as if you wouldn't drive a car stupidly just because you're off the main road. So that deals with those things. And our case is really that those external restrictions, including the bylaw and the maritime rules, already deal with a lot of the potential for conflict between jet boating and other river users that's highlighted in the Section 32 report, such as trap fishes, stuff like that. And so our focus has been on providing what we know about the frequency of jet boating, and it does happen outside the August to September window currently because uplifts are available. And then we've really tried to be constructive in response to concerns about trout and trout fishing, and that you'll see that in the proposed rule, because that's the sort of effects that I think this process and these rules are about. And then there's the biodiversity concerns raised by DOC. I suppose, I mean, reluctantly I set out the relevant law about that, just in terms of when a precautionary approach does need to actually be available. It's not something you just have to do. It's something that there's still evidential thresholds for, and we don't have that evidence. We've got what JB&Z knows and can comment on, but we don't have that involvement from another submitter. So what I can really say is, in terms of dealing with those effects, is the pragmatic rule we've put forward does keep jet boats off the river for almost the entirety of that 3-month period which DOC have identified in their submission as the key breeding period. And that must be a significant way of dealing with the contended effects, particularly without hearing more detailed evidence about where the birds are on the river. And I know most of it's banked in the Gore district. There's about 9 k's upstream from the aerodome that's braided, but most of it below that's banked. So it doesn't have that unique braided river characteristic that they look for in the Queenstown, the Dart River and places like that. So really I think we're just trying to create a situation where, yes, there might be a greater allowance in the district plan for boating, but keeping in mind those external restrictions and keeping in mind what's actually been put forward in terms of the birds, basically. There'd still be pretty limited usage and conflict around those areas, while coming back to the objectives of this chapter, you promote those recreational values for 6 to 9 months of the year when the river's boatable and it's not heavily used by trout fishers.
So I see in your submission that you were saying that the birds leave their nests, but they quickly come back to their nests. Is that your observation on what is happening on the river?
yeah, it is an observation. So obviously there's, like as Kyle said, there's no evidence, but like typically you get a group of boats, and the thing about the river too is it is a reasonably bank to bank. It is a wide entity. Like you've got, you know, a large amount of gravel. You've also got a large amount of water. So we aren't scooting past sort of from a metre away from them. A lot of the times you're going past at lower speeds anyway, and You know, if they do lift off, they might lift off with the first couple of boats that go past, but typically they get used to it and they do come back, definitely. And sometimes they don't lift off at all. That's from an observation. Yeah, and we were pre-boating the Matera. It made me think of it. We're pre-boating the Matera before the racing that was held last week, and I actually noticed it a couple of times, specifically looking at birds that were on the beach, knowing that this was coming up, and sort of wishing that we could have probably had some sort of evidence to show that. But they do typically lift off and come back. So, yeah.
It was one of the observations in one of the papers he cited. It was a 2022 thesis about Canterbury rivers, and they were surveying a bird's response to a few different kinds of activity. And one of the things the now doctor said was, I did note the birds stopped flying past after the first couple, or after a while, or after a few boats, and she couldn't really mesh that with the sort of common sense thinking that they might be flying away and leaving the nest. It was outside the scope of her paper, but I thought it was interesting, and obviously a really recent piece of research focused on that. So, and that it probably, if you step back and think about again the coexistence of jet boating with the biodiversity on the Matoda for 60 years, it's probably not as surprising as you'd think to think the birds just come back and they get used to it and they adjust. So if you've got not a routine, but if there's a regularity to jet boating in periods that perhaps aren't in the height of breeding season, as we'd suggest, and you're not lumping it all on one day, for example, as you might if there was a sort of a discretionary rule that focused on singular events and that's people's only opportunity. That's actually a way, I think, of reducing the effect.
And there's no concern about wash?
Wash.
Yeah.
Well, we don't have a hydrologist or anything, but I suppose, again, common sense observations, particularly for Mr. Barker, would be it's all dependent on flow. So if you have enough flow to run the river, there's going to be a fair bit of flow to stop it going across the sides. It's not going to be as big a wake relative to the flow of the river, and like he says, they're not cutting corners or flying right next to the birds. And it's another thing that's touched on in the 32 report to be conscious as well as it is a river that goes up and down quite heavily. So I think pinning it all on jet boat wake wash once every now and then is unfair is not the right word, but I think you get the sentiment I'm sort of aiming at.
The wash or wake from a jet boat at planing speed is actually very minimal. And if a bird was nested so close to the water that it was affected by that, there's probably a higher chance of getting washed down by flood. And that is the biggest, their environment is actually the biggest threat to them, unfortunately. The water, you look at the picture on the front page of the Ensign this morning, it was like, extreme flooding last month. That happens fairly regularly on the Matera, I would think.
Yeah. The other question I did have for you was, in your submission, you were saying that it's regarding the activity on the river and their associated facilities and structures, whilst also reasonably enabling shared use and enjoyment. So what did you
Paragraph you had, sorry.
Paragraph 64, page 17 of the 42A report.
Oh, so that was in relation to the objective number 2 concerning mana whenua. Yes. I mean it's a pretty general remark, just wanting to remain involved in the discussion around how we regulate access to the waterways. I think you might be able to speak to this, or actually Eddie could, but what's the hui you've been to recently?
The reimagining Matera. Is that it, Eddie? Is that right? Yes. Yeah, I wasn't able to make it, but we were actually had the opportunity to attend that. We were asked to attend that as another river user. So we are as an organisation, we try and engage with other river users, and local iwi is one of those affected parties that we are working on relationships with. So Eddie and Andrew Colley down the back there both attended the hui recently. So yeah, it was good to be a part of that.
I think you said that Kaumata was wanting to do a scene view like I did this morning. Is that right? Trip on the water and see how it goes. So there's a level of engagement there, and I think that's really what the submission at 64 spoke to, was just wanting to be involved in those conversations.
Reasonably enable, that was the word that I just wondered what that meant.
I think that's really just focused on wanting to be a part of the discussion, knowing that, multiple voices in the room, and there's not always one answer when you're dealing with multiple voices, and that's what reasonably enabling is sort of geared at.
I've got questions. I've always got questions. So when you were talking about the 60-year history, is the pattern of usage that's reflected in the bylaw largely what we've seen over that 60-year period? Like, is this window that's captured in the bylaw, has that been the typical pattern of usage with sort of spot infrequent uplifts outside of that window? Has that been the norm for all of those decades?
Eddie, do you want to comment on that?
Do you mind me moving up? So, in prior to 1978, before the recreation water regulations come into force, you could boat any water body in New Zealand at any speed. So, prior to 1978, you could boat the Mataura any time you liked, any day you liked, right throughout the year. In 1978, the government brought in the recreational water regulations, which limited all internal waterways to be restricted to 5 knot speed restriction. And that's when New Zealand Jet Boat Association, which was called then, or Jet Boating New Zealand as it is now, got on the bandwagon to start getting gazette notices and getting uplifts on rivers throughout the country. So what happened in Canterbury is basically they got all the rivers uplifted in there. There was a lot of rivers throughout the rest of New Zealand uplifted. In Southland, we had the Acclimatisation Board basically saying that jet boats and fishing don't combine. So they managed to they had a very strong influence on the government at that stage, and the Ministry of or the MNZ, Maritime New Zealand, to restrict when we could get upliftings down here. So hence we haven't been able to boat as freely as we did prior to 1978. And in fact, it's been a real struggle getting stuff through the Acclimatisation Board and now Fish and Game, who they are known as now. We have a better rapport with them over the last 10 years probably, and we have been getting a lot more one-day upliftings on various rivers throughout the region. So, in answer to your question, is yes, prior to 78, we did a lot of boating. Not that I was boating then, but I started in 81-ish. So, but our idea is that, what we've noticed is that when we get these one-day upliftings, we get 60 or 70 boats on them, which is probably not good for the environment. Whereas if you could spread it over more upliftings or have the rivers opened more frequently, which is where Environment Southland are looking at, we don't get as many upliftings. So we'll take an example, if you like, if I've got a couple of minutes. We have a run from Dipton to Mosman on the Arete, and we used to have that once a year. And we would get up to 80 boats on that run for that one uplifting, because people knew it was the only time we could get it. Now we get 3 upliftings over the course of a couple of months,
and the numbers have dropped, what, down to 30, 40 boats?
Yeah, maybe even a wee bit less than that.
Yeah, per run. So people are now spreading out when they can do that run. And it's the same, we get an uplifting from Ardlassa through to Eyre Creek on the Mataura River, and we can have 70 or 80 boats on that run if the weather's right. So it's about, you know, having more frequent runs but less boats, if you like.
So a jet boat couldn't plane on 5 knots, I'm taking. So how many knots do you need to actually get up to plane?
Depends on the boat. You know, the wider and the shallower V in the boat, the less it needs to plane.
About 15 to 16 knots.
Yeah, which is
Yeah, something around that. Yeah.
about 25k you can get down to. So the getting back to the frequency and the timing. So the Fish and Game brought in that they would allow us to run that August, September, and that was all about not being within fishing season, not being within duck shooting season, and not being in fish spawning season. So they gave us 2 months of the year, if you like. But we would like to expand that.
It seems quite incredible to me that they allow only that time, and that's nesting time, basically, isn't it, for birds in that time frame?
But Acclimatisation Society weren't worried about that. They were worried about duck shooters and fishers. And 75% of jet boating members hold an angler's licence or a hunter's licence.
So you were just saying that Environment Southland's re-looking at all of this, or did I hear that?
No, it comes up for review next year. The district plan is reviewed every 10 years or thereabouts, as you guys know. Maritime New Zealand require the navigational safety bylaw to be reviewed every 5 years.
So I've got a bunch of questions. I might, before circling back, I might have a conversation with Mr. Barker and Mr. McKenzie. Is it Mr. McKenzie?
Yes.
Yeah. So I was wondering, are most of the jet boat owners and operators running on the Mataura members of Jet Boating New Zealand, or what's your feel for the ratio of people who are members versus not members who are using the river?
Probably it would be 50%. There's a lot of farmers, etc., that have boats out there that use the river. Not necessarily down as far within the Gore District Council area as much, but more up towards the Waikaia and Nokamai areas. Of course, there are the ones down below, down Seaward Downs Way, probably use the river quite a bit as well. But yeah, just because you own a jet boat, you don't have to be in the Jet Boat Association.
Can I just add to that? I think the numbers that Mr. Barker has put forward, that was intently done by speaking to a few people to comment on members and non-members numbers. We weren't just trying to give a snapshot of JBNZ because that probably wouldn't be that helpful. So I just thought I'd add that.
Are there any health and safety incidences on the river because of more users?
What I will say about health and safety, like probably some of our other runs have highlighted that more recently, is because we get 1 day a year and potentially one cancellation date. You know what the weather's like in Southland. Sometimes we find ourselves having to run the event. We've paid for it. Our members expect an event, running it in snow. Like, so it's all good if something, if nothing happens, but something does happen, I guess, from a safety aspect, if we could pick our days better, if you had more of a blanket arrangement rather than we've got one day, rain, hail, or shine, we're going to have to run it. It's one way of looking at that, I suppose.
So maybe I am asking a question because I had this question down sort of for legal, but I think it's just a combined question because one thing that occurred to me was one of the issues that comes up for us is the lack of evidence in front of us to consider all of the matters that might be relevant here, including what Doc have put on the table. And the Section 42A officer has said, well, it would be easier to deal with those matters through a resource consent process where you can cover off all that stuff. So what I had been wondering is some of what's sitting there in this proposed PA rule, it occurred to me that if Jetboat New Zealand was holding a resource consent, it might provide more certainty and more flexibility than a permitted activity rule in the district plan. And it would enable a more fulsome consideration of these angles. And the one reason, I guess there's a legal component to this, which is that, of course, a PA is subject to the life of the plan, depending on how long that is, and potential plan changes. A resource consent is something that can be held for up to 35 years. That's the maximum extent of a resource consent. So thinking about how there are different ways to achieve, I guess, what Jetboat New Zealand are trying to achieve for jetboat users. And one thing a resource consent can do can manage these kind of impacts that you're just talking about, which is the number of users and the timing of events, and frequency of events, so that you can start to have more influence on those matters.
I think the concern that JBNZ has is perhaps an unintended consequence of going down that road as much as anything else, is that your casual jet boaters who want to go out with their family because it's nice on a Saturday morning and they've worked all week, those people then would have to get a resource consent if they're not part of JBNZ's coverage, I suppose.
But they could potentially, they can still rely on the window of time that's available for all. And the only thing, I guess, would be that for infrequent uplift outside of the bylaw window, that's the only time that those users would be impacted. But if you've got a sort of a managed situation where opportunities outside the window are effectively being managed by Jetboat New Zealand and provide more opportunities over the course of a cycle or a year, that may address some of the unknowns for us in terms of those other users that are either not regulated by a resource consent. We're talking about they would still have to get the uplift through the bylaw process like we talked about. But we really can't sort of foresee what the potential impact of making these changes is.
I suppose it just comes back to what I was talking about before with needing to factor in all of those other regulations and constraints that already exist. So of course there's the bylaw, which is, as I understand it, it's at least a 7-day notice period after you get it before you can exercise it. So there's a restriction there. But again, we come back to, you need the time, you need your boat to not be broken down, you need the flow to be right, you need conditions to be good. So I'm not sure the evidence is there either to regulate on the basis of sort of mass usage, because I don't think we're at that point, and I think there's other things in play that would stop us getting there. And so that's where we come back to what I've said in the submissions about, the least level of regulation required to meet the objective, And in this case, it's an objective which promotes access to the river. I think it can be done through a permitted activity rule that spreads jet boating across that several month window, but keeps it off the river during the important times for anglers and the important times for birds based on dock submission. I'm trying to think about how you could otherwise draft the rule to get at the concern you've raised, but I suppose my key point is that the evidence suggests we're just not at or going to get to that point if the rule we've put forward is adopted.
I'll let you consider that for a while. I've got a question about your dealings with the regional authority and the restrictions of the bylaw. How restrictive do you find that bylaw? Or is it enabling? Or what's your opinion on working under the bylaw? What I'm asking you is the bylaw sufficient in itself?
Well, it's good it's up for review. Probably in my statement, like my evidence that I put through is from like sharing the values of the waterway and sort of, I guess, from the perspective of a jet boater. And yeah, I think Southland, I made comment in there about Southland having one of the greater restrictions on boating of regionally in New Zealand, basically. So it is tough, like it's not, and I guess that's why people take opportunity to boat whenever they like. We can't control non-members and what goes on outside of our membership, but it is fairly restrictive on recreational jet boating. Yep.
So I need to follow up on our last discussion because I'd read what you were proposing in 4 is in 5 really is it was putting Jet Boat New Zealand at the core of the permitted activity rule in terms of managing access outside those times, which is why I was asking the question, like if Jet Boat New Zealand held a resource consent to do these things, it might well provide a greater longevity than the plan itself in terms of the life of the plan versus the life of a resource consent. It would also provide for Jet Boat New Zealand to have, tease out the timings and frequency and number of users and how events are managed and all of that stuff. So when I read what you've put forward here in the permitted activity rule, it's not really thinking about additional opportunities for the non-members.
I'd put it...
Am I missing something in the drafting?
At 4A, I've got the activity including casual boating and events.
Oh, see, I was reading the phrase is casual boating and events organised by... Oh, okay.
Apologies, yeah. So
No, it was how I read it. It's not anything...
I got confused by the same wording or similar wording in the proposed rule because I wasn't sure whether it was saying only JBNZ events or including JBNZ events, inclusive as opposed to exclusive. So that's why I just added the casual boating part to make it sort of double clear. I'm not sure if it's necessary, but I hope that clears up where we're at.
It does, because I honestly hadn't picked that up quite right.
No, and I now can understand completely where you're coming from as JBNZ saying it wants to be the one that runs it, but it also doesn't want a discretionary rule. But no, the point is that we want a permitted activity rule for casual boating and jet boating New Zealand events.
And the way the comments are put there will clarify that.
Yeah,
it's easy to redraft so that it's not a problem.
It is important to understand too that we are talking about recreational boating, so we're not talking about being able to race on the rivers. They're two completely separate things. I know I made it quite clear in my submission, but Recreational boating is quite different to racing, which is holds its own activity permits. So it's we're talking about recreational boating,
Yeah.
slower speeds, family days.
Yeah, different purpose for getting on the water and completely different speed and manner of driving.
Any more questions?
I'm just reading through to see.
Yeah, sure. Is there anything else?
No, reading through all of my notes and questions, I think we've gone around them all. So thank you very kindly.
Thank you for your time.
Thank you for your presentation. Again. You'll hear from us. And moving through our program, we've got Louise Taylor from Kiwi Rail on Zoom. Welcome, Louise. Good morning. We'll hear your evidence or submission when
And Louise, there was some supplementary evidence that we received from the planners this morning, and my recollection was that they saw merit in what you were suggesting for that rewording, nodding heads from the other side. So just in terms of coordination across the other provisions, if there's something that's put in here, does it need to be in the individual zones then? Yes, no, asking you.
Yes, no.
Was there anything else?
Just a question around that, bearing in mind that you're a requiring authority, a designating authority, why do you need an exclusion from within the plan? Thank you.
Is there anything else on that, Michelle, or is it?
I've got
So
no
that was-
further
that was
questions.
all that- Sorry, was there another question there?
No, is anybody else? Yeah, Maria, thank you.
My question is actually just to check in, because we only got the supplementary statement this morning, just check in. When I look at Ms Taylor's paragraph 6.0, so her conclusion, she's listed out the changes that she's just outlined for us. And can you let us know from your supplementary statement the status of each of those matters? So if you're looking at Ms Taylor's paragraph 6.0 into your A, B, C and D, can you highlight for us how you've responded to that through either the supplementary, any update, or just the status of where you're at and your thinking in relation to all of them? Oh, sorry, I'm looking at the wrong person. I'm so sorry. We've changed subjects. I'm so sorry.
That's okay. As Keith mentioned earlier, I was supportive of Kiwi Rail's amendments to the critical infrastructure definition, and I've outlined my reasons then, but they broadly align with Ms Taylor's. So happy there. And in terms of infrastructure standard 4, I haven't used her exact wording, but I feel like I've got the intent there. But Louise, the supplementary evidence is online if you do want to have a quick look, just on the hearings page. But I've suggested, and if you look at Appendix A of my supplementary evidence, Infrastructure Standard 5, no, sorry, Infrastructure Standard 4, Matter of Discretion 4, I've amended it so it's impacts on the safety and functionality of the road and rail network, including any footpath or cycleway. So I hope I've landed on the intent. I just tried to streamline it as much as possible. That probably covers A of your point. B, I think, is already covered with 3 of the matter of discretion, and then C, the reason for the reduced setback. I think if we're having to assess the impacts on the safety and functionality of the rail network, that probably covers that too, but I'm happy for you to have further comments to that regard.
Yeah, look, that sounds like it might solve it. I guess the only thing I would say is that if council, if you make a decision to do a similar rule as Kiro has sought in relation to the zones, it would be sensible, I think, to be consistent with those matters of discretion through the plan.
And the Mataura floodway earthworks, yes, that's it. Yeah.
Thank you. Yes, so I have actually rejected Ms Taylor's suggestion there. So the Mataura River floodway is a high-risk flood area. So works within the designation would go through an outline plan process. So there is a process in place, but I don't think it's appropriate to permit activities because then there wouldn't be a process to go through at all to manage that flood risk, and we don't know or we don't have any flood risk evidence at the moment, and this is a specific project in relation to the Mataura River Bridge, and I think that the resource consent process is the appropriate one rather than making a permitted activity rule for those reasons.
Could we then think about, because I think one of the strands that's coming through the evidence from KiwiRail is the activity status, and so we've got a relationship here between some critical infrastructure that we know needs upgrading, so we can see a project in the works, and at the moment the way things are written, we'd be looking at the project on this sort of quite narrow area of outside the designation, not within regional council jurisdiction, so earthworks that are sitting somewhere between the river and the designation boundary, so quite a confined area, and in relation to a known need, of critical infrastructure that we can see in the life of this plan. Are we able to think perhaps about that non-complying activity status and how we work with that in relation to critical infrastructure? Perhaps that's where the overlap is, and is it potentially a discretionary pathway or a restricted discretionary pathway, something else that's picking up what you're saying, which is a permitted activity standard is perhaps a step too far, but somewhere between there and non-complying, which from the applicant's perspective is a step too far as well, and I think probably out of alignment with the general direction of objectives and policies in relation to critical infrastructure. Like, it's responding to the hazard risk and that high hazard risk, which is appropriate, but we're looking at a mix of things here, and one of them is the need for that critical infrastructure. So is there a pathway maybe?
Yeah, I think there could be, because we wouldn't want to get into a potential situation where we couldn't grant a resource consent because it wouldn't meet the 104D. So I think that might be, that would be a good approach, to perhaps have a separate activity status, still send a clear message that this is a high risk area, but there are some instances where the activity in itself is also of significance.
And so if we're thinking like that, and we're thinking about a known piece of critical infrastructure that KiwiRail have brought to our attention, and so their solution obviously was to go, well, there's a way we can do this for the rail network, so let's pop that exemption into this rule and deal with us. So the question then is, are we responding, when you're thinking about this, are we responding to this particular situation for the rail network? Do we need to think about this more broadly in relation to critical infrastructure? Yeah. And then if there is some reworking that goes on, the kind of process around that, I guess.
Yes, so I would have to go back and look at original submission as well to make sure that this is covered. I think it possibly is, but I would have to make sure.
Okay, thank you, KiwiRail, and you'll hear from us. How far are we through now?
Many, thank you. Also, just wanted to give you a very quick update on the work that's going.
Okay, thank you very much.
The
Thank you
next
for having us.
The next person we've got is from PowerNet, but I need a 2-minute break first, please.
I'll just adjourn briefly and then we'll come back to hear from you guys. Thank you.